most of you will know this already, we're all old hands on Zoom, but there's a Q&A function which you should find at the bottom of your screen. So first of all, thanks to all of you who sent us preloaded questions, as it were. That's extremely helpful, and we'll try and deal with those towards the end of this webinar. But you can also ask or suggest questions via the Q&A function as we speak, or if they occur to you, or if there's something that we say that doesn't make sense, or that you want us to say a bit more about. If you do that, we will do our best, no promises, but we'll do our best to answer those as well as we go along. But because there's only two of us, Harry and I, one of us will be speaking at all times, at least one of us, so the other one will try and beaver away and collate the questions and give a sensible answer. But I think we have to probably be reasonable and say that we can't promise to answer all of them, but we'll certainly try. I think we're up to 76 attendees now, which I think is probably as good a time to start as any, and we're a few minutes after 2:30, so I think we'll get going. I'm going to unshare my screen so you get the full glory of my whole face. In a minute I am anyway. Okay. So, as I said already, thank you very much for signing up and coming along. As you can see, I'm sporting my lockdown non-haircut. I'm doing my best to keep it under control, but I think it's 6 weeks and counting now, and I do really need to go and see a barber. I don't trust my wife to cut it, or rather, I don't trust myself to trust her to cut it. Harry looks much smarter than I do, but he's got a very skillful hairdresser. Actually, she's a milliner, Harry's wife, so she knows all about what goes on the top of one's head. Mine's a sustainability consultant, so no idea at all about such things. So what we're going to do today in the next 45 minutes or so, Harry and I, who are both to a greater or lesser extent barristers and mediators. Harry doesn't really practice as a barrister as much as I do, and I don't really practice as a mediator as much as Harry does, but we both do both. We're going to talk about why mediation might well be the answer to a particular problem with planning enforcement that exists at the moment in the lockdown and what follows. I'm going to start with a bit of background and where we are in terms of getting cases progressed. And then I'm going to hand over in 5 or 10 minutes to Harry to talk a bit more about how mediation works. And then we'll try and put that stuff into the context of planning enforcement before hopefully taking some questions and hopefully answering some of the issues that might surround it. So what's the problem? Well, as you all know, when lockdown was announced at the end of March, PINS, well, perhaps not straight away, but relatively swiftly, announced that it wasn't going to hold any what it calls events, so inquiries and hearings, but also site views and so on. It basically went into the deep freeze. It postponed all of the events that it had listed until, I think, the end of May. And there's no sign as to when they might start again. In the meantime, lagging behind almost every other dispute resolution organisation, PINS have said they are thinking about moving to digital events. But the latest news from them, although this was met with a fair bit of horror from the planning world, was that they might be ready to have a go at digital events in earnest in 6 months' time. But whatever else is true, and however else they get to that point, face-to-face old-style inquiries and hearings are going to be a long way off. They don't fit with social distancing rules. It's going to be extremely hard to get everybody into a room, travelling, so on and so forth. And even when PINS does finally get up and running with digital events, it seems to us that there will be a pretty major backlog for a couple of reasons, really. First of all, we'll have had, if it is 6 months, we'll have had 6 months with nothing getting decided. So that's a kind of classic backlog, in that all the cases that should have been decided between March and September, say, won't have been decided. But I dare say also that when they do start going with digital events, they won't be able to run them at quite the same pace as they can run in person or could run in person events. So I think even once they get back up to speed, it won't be full steam ahead from 6 months' time. So I think we are looking at a fairly major slowdown in getting any planning appeals decided. I think almost everybody has to accept there's going to be a delay in that. And it seems to me, although PINS haven't said so in terms, but what that will mean is that there will be some prioritisation of the cases that they do handle, whether by digital events or by some other means. And I reckon that enforcement cases will be relatively low down on that list. Now, I'm not saying that they should be, I'm saying that I think they will be, and I'll say why in a minute, but I know that Teresa Campion, hello Teresa, said, you know, why are enforcement cases going to be bottom of the list? And I sense that was a bit more of a rhetorical question. They shouldn't be, but I think they will be. Because, first of all, as you may know, enforcement cases are exempt from the Rosewell review targets as to how quickly you have to decide appeals. And we know that PINS are very sensitive to those targets, but of course enforcement cases lie outside of that. So there's no impact on meeting targets and so on if enforcement cases are at the bottom of the list. Secondly, lots and lots of enforcement cases, I think all that involve ground D and therefore evidence on oath, have to be done by way of inquiry, and there isn't really a way to downgrade those. And they often involve cross-examination, and the general feeling amongst the, I don't know, litigation community is that cross-examination is perhaps the hardest of all the parts of an inquiry to replicate digitally. So I think that's another reason why they'll be a bit lower down that list. There's also a sort of wider reason, which is that I reckon enforcement cases don't fit quite so easily into the kind of economic recovery agenda. So planning cases for new houses and infrastructure and so on and so forth will very much be part of the government's let's get business running again. Whereas to some extent, enforcement cases, the work's already been done, the money's been spent, and you're trying to undo something that's already been done. So again, I think it won't fit with that. And in any event, enforcement cases already take longer than any other kind of case, according to PINS' own figures, although the eagle-eyed among you would have seen that PINS have now removed all of their average determination times from the website, from the gov.uk section of the website, citing COVID-19 as a reason, I don't know, not to give us false hope or something. So we can't find that out anymore. But before they removed them, enforcement cases were at the bottom of that list, or the longest. So all of that, to me, adds up to this conclusion that there is an overwhelming likelihood that your enforcement cases are going to be subject to a considerable delay before they get resolved, not just for the lockdown to end, but for some considerable time thereafter. And I think more than that, the beady-eyed landowners in your authorities may well know that and may well factor that in when deciding how to deal with their appeals. Of course, an appeal in almost all cases suspends the operation of the enforcement notice if it happens to be an enforcement notice. So there is an issue, and that's what we have been thinking about, and why we get to this point about suggesting perhaps mediation might find a speedier way to resolve it, because of course that reality, the reality that enforcement cases are going to be subject to a considerable delay before being resolved, is an unhappy reality, because all enforcement cases, almost by definition, are about harm that exists now and is ongoing until resolution. Contrast that with planning appeals, which are often about how much harm will this proposed development cause if it's allowed. With enforcement, the harm is there now. So I think, Teresa, this is probably behind your question. There is a particularly unhappy ramification of enforcement cases being at the bottom of the list. So that's what got us to thinking about mediation as a solution to this particular issue. I'm going to hand over to Harry, who's going to talk a bit more about mediation generally and how it works, before we come back and try and put that into the context of planning enforcement cases.
Thank you, Joe, and good afternoon to you all, and thanks for joining us today, and thanks for sparing the time. I don't know if any of you are involved in homeschooling in the way that I am, but I'm particularly pleased about the timing of this session, because Monday afternoon is when my 10-year-old would normally, well, in fact does normally have double maths, and so but for this webinar I would almost certainly be getting myself embroiled in double maths myself, a sort of nightmare of long division or something equally hideous. And so many thanks to you all for providing me with a pretty cast iron excuse for getting out of that. I have to say it's quite a long time since I found myself looking for excuses to get out of double maths, but as they say, we live in strange times. Thanks, Joe, for the intro. What I'm going to do is to provide a basic intro to mediation before we start to talk a bit more about how we think it might apply constructively to enforcement cases. And in so doing, I'm going to assume a relative lack of exposure on the part of most of you in the audience today, which reflects my experience, which is that mediation doesn't yet form a central part of the dispute resolution culture in the local government world. But for those of you to whom this is teaching grandmothers to suck eggs, then apologies, it won't take very long in any event. Mediation is essentially a negotiation. It's a negotiation whose objective is an outcome that works for all sides. It's about achieving a compromise that is acceptable to all parties, irrespective, or at least almost irrespective of the legal merits on both sides. And so really it's about doing a deal more than it's about reaching any kind of judgment on the arguments on either side. It's a negotiation that is entirely voluntary, it's entirely confidential, and it's also without prejudice and non-binding, at least up until the point at which a settlement is reached at the end of the day. And it's facilitated by a mediator. That's a third party neutral, who's a professional and whose role is to provide the framework within which the parties can conduct that negotiation. Typically, a mediation takes place over the course of a day at an agreed venue, which in the normal world would offer a set of rooms within which the mediation takes place. And that would normally include a large room for what we call joint sessions, which are when the parties gather together for a group phase of the negotiation, if you like, and a series of private rooms which can offer a private space for the parties to conduct their own discussions, both without and with the mediator, who will often spend a certain amount of the day shuffling to and fro between rooms as he or she works to build agreement over the course of the day. And usually, and hopefully at the end of the day, an agreement is reached, and that will be expressed in writing and signed up to by the parties. And that's what happens in a high proportion of cases. Statistically, something like 85% of mediations result in a settlement, which is, on any analysis, a measure of real success, I think. Why does it work so well? I think there are 5 key reasons for this. And the first is that the voluntary, the confidential, and the without prejudice nature of the mediation process combine to create an atmosphere that is conducive to the sort of compromise, to the sort of openness and negotiation that is essential to a positive outcome. The fact that it, by contrast to litigation, is non-adversarial in the sense that the parties are working together to achieve a common objective, namely a settlement agreement, is also important and powerful, I think. And third, and I think more importantly still, is the flexibility that mediation offers. And I say flexibility in 3 different respects. Firstly, the process is capable of being defined and devised to suit the situation and the parties, to work with the parties and their constraints and the complexities of the dispute to make it more likely that a settlement outcome is achievable. And that's in stark contrast to litigation, which offers nothing of that process flexibility. It's flexibility It's flexible for the second reason, because it is able to take into account a whole range of factors that would be treated as either irrelevant or even inadmissible in the context of litigation. And I'm thinking about things like commercial intentions, public reputation, perhaps. Those are factors that a mediation can be sensitive to and respond to. And it's flexible in the third respect in this sense, which is that it's capable of providing in the settlement agreement for a range of measures or steps that are firmly outside the scope of that which a judge or a planning inspector could include in any decision. And that might include anything from the way in which the decision is publicized or not, to practical steps that are agreed upon by the parties insofar as the way in which, for example, land is dealt with. I think the fourth factor is the skill of the mediator, and his or her role will be to apply his or her understanding of the psychology of conflict to help the parties to move from a position of conflict to a position of compromise by working with them to understand what's important about the dispute to them and where particular matters are of less importance, to explore, understand, and to recognize weaknesses in their cases, to identify areas of common ground, and also to help to build and to move towards settlement, and then to craft the settlement at the end of the day. And I think the fifth reason why mediation is successful is simple. It's successful because it's quick and cheap. It can be set up and delivered in a matter of days. And by comparison to a typical enforcement appeal, or indeed most equivalent forms of litigation, it's strikingly cheap. And those are the reasons why it's increasingly in use in civil litigation. It explains why judges are increasingly making awards of costs against parties who decline to participate in mediation without good reason when they're offered an opportunity to do so. And it's why there's been repeated encouragement from government to the public sector to include in its dispute resolution toolbox mediation. Encouragement that I think largely so far has fallen on, therefore, at least sceptical ears. And it's why only last week, actually, the All-Party Parliamentary Group on Alternative Dispute Resolution held a discussion to explore the increased use of mediation in the planning system specifically. My experience is that it's a dispute resolution mechanism that is benefiting from increased awareness, from increasing support in the world in which we all operate, the local government world. Joe and I both think it's on the way, and our invitation to you as those involved in the local government world is to explore it, and we're confident that you'll see what a powerful tool it can be when it's used effectively in the disputes that you have to deal with. So that's a brief introduction to mediation in the general context. And I'm going to hand back over to Joe now, who's going to talk about why I think it works and is a good fit in the planning enforcement world.
Thanks, Harry. As Harry says, I'm going to put what he said in sort of general context about mediation into the quite focused context of planning enforcement. But I just want to put a caveat in early on that what I don't think either Harry or I are telling you is that every enforcement case that you have on your file can be solved by mediation. That's obviously unrealistic. There may be some that are completely intractable, just as in civil litigation or any other kind of litigation. There are some disputes which mediation doesn't solve. That striking statistic that mediation is successful across the piece in 80% obviously means that in 20% of cases it doesn't succeed, and those are the cases that go to mediation. But nonetheless, 4/5 success rate is pretty extraordinary. At the moment, I don't think it's used at all in planning enforcement. I've only really heard of it in a very few cases tangentially linked to enforcement. And so the question is, can we translate something of that success rate in mediation generally to planning enforcement cases? And I think the answer is yes. And I've really got 5 sort of features of planning enforcement, which to me show that it is a good fit for mediation and ought to produce a decent success rate if planning enforcement cases went to mediation more as a matter of course. The first one is that my experience of enforcement cases is that they are often personality driven, or at least affected by a personality type dynamic. So often the recipient of an enforcement notice, not exclusively, but often, is not a large organisation. It's an individual or a small business or a small scale landowner who has tried to do something with their land or on their land and found the council in their way. You know, got this enforcement officer down, sticking his or her nose in, starts to entrench his or her position. I don't like the council sticking their nose in this way, which leads to frustration, but also a certain amount of stubbornness. Why should the council tell me what I can and can't do on my land? And actually, mediation is completely tailor-made for situations in which personal dynamics of that nature are a block to moving forward. And the problem with the enforcement system is that it provides for the enforcement litigation system, so appeals, it really provides for a winner or a loser. You either win on your grounds or you lose. So it's quite linear in that way. What mediation does generally is try to move a dispute away from entrenched positions and the idea of winning and losing, the kind of zero-sum game of one person winning and one person losing, into the territory of finding mutually acceptable solutions, which don't necessarily follow that same linear route. So is there an outcome of this dispute which perhaps doesn't involve either side winning or losing, perhaps thinking a bit more laterally rather than linearly, which is actually okay for both or all sides. So that's the first reason why I think planning enforcement is ripe to be tried in the mediation sphere. The second point is sort of related, which is that, and I say this as a barrister of 18 years call or something, the rules, the enforcement rule, planning enforcement is complex. You know, lots of landowners don't understand it. I mean, those of you who regularly look at the GPDO, for example, I mean, it's difficult to get your head around. If you're a layperson with not much time, it's pretty easy to go wrong. Even if you're a barrister with not much time, it's easy to go wrong. And I think it's right to say that most recipients of enforcement notices, not all, but most, didn't mean to breach planning control. They just tried to either push the boundary or do something that they thought would be okay. So, and what led them there was a misunderstanding perhaps of what the rules were. And the other thing that mediation provides is without sounding too woolly about it, a kind of safe space, these confidential rooms that Harry was talking about, for a greater understanding of why each party is in the position that they're in. So for the landowner, recipient of the enforcement notice, an opportunity to understand a bit more in a slightly safer space why it is that what they've done is considered a breach of planning control and why the local authority is bothered about it. And I think what that can often lead to, once there's a better understanding, is a move away from that entrenched position and even a sort of ladder to climb down. So sometimes, having put in your enforcement appeal, I can't believe the councillor trying to stop me do this thing. Once it's quietly pointed out that actually you're probably up a gum tree in terms of the point, what you're looking for is a ladder to climb down. And mediation provides that in a sort of mutually cooperative space rather than in the winning or losing environment backed by costs of the enforcement appeal regime. The third one is something that's true of all planning disputes, but particularly enforcement, is that at the end of a planning enforcement dispute between a landowner and the local planning authority, they will continue to be in a relationship. The local planning authority will still be the LPA for that area, and the landowner, unless he or she sells their land and goes away in a state of high dudgeon, will still be subject to that authority's enforcement officers, so on and so forth. So the other hallmark, if you like, of mediation is that it has a very good record in, as Harry said, in maintaining relationships beyond the dispute. So because it's a collaborative process which involves cooperation, often the parties come out of a mediation, whether or not it succeeds, and again, risk of being woolly, just feeling a bit better about each other and about the relationship between themselves. So what mediation allows is a way of dealing, even not necessarily resolving, disputes which can maintain a decent relationship even after the dispute has been dealt with, whether it's resolved or not. And it doesn't tend to be, and this isn't true of every inquiry, but lots of planning inquiries I've been to can get bad-tempered. You know, the neighbour who complained is there, the local planning authority is there, the landowner themselves is probably pretty cross to have to come all the way to the council offices and explain themselves, probably pay for a barrister to represent them. So there's a kind of bad-tempered element of that. And mediation is not usually bad-tempered because of that sort of collaborative, looking for a solution sort of dynamic. So the ability to maintain ongoing relationships where those are basically inevitable in the planning sphere, I think, is another advantage. Fourth point is kind of lockdown specific, which is that a point I already made, that almost by definition an enforcement case comes because somebody, usually the planning authority, thinks that something that's being done is harmful. So there's a kind of ongoing extant harm. And in the current circumstances, that means there is a real and powerful public interest in resolving that question quickly. So if you can resolve an enforcement case by mediation quickly, compared to 12 to 18 months waiting for an appeal to come on when PINs finally get their act together, then I think there's a real public benefit in that, and another reason why enforcement is ripe to be tried in the mediation sphere. And then the last point is a sort of technical one, which is again related to something Harry was saying, but an inspector on an enforcement notice appeal has pretty limited powers. Obviously they can grant planning permission under ground A, but only for the development that was applied for. They can't sort of step outside of ground A and consider other schemes or other buildings or other ways of achieving it. And the legal grounds are pretty narrow as well. Either is or isn't a breach of planning control. You can't get into questions of planning merit or alternatives or so on. So you've got really quite a narrow scope, most of which are kind of binary. Either you win or you lose on those grounds. Obviously ground G provides a bit of scope in terms of time, and ground F provides a bit of scope in terms of doing something less than asked. But the courts have narrowed ground F recently too, just to make sure that you don't stray beyond the fairly focused nature of those powers on appeal. By contrast, mediation is not limited by those powers. You know, mediation, a mediation and a mediator can consider, and parties to a mediation can consider solutions that go well beyond winning or losing on grounds A through to G. They can look at land beyond that affected by the enforcement notice. They can look at all sorts of things. Obviously, time, lesser steps, and so on too, but the view can be much wider. So again, I think that suits planning enforcement for that reason. So the obvious question is, now that we've sold you all on the idea of mediating planning disputes, well, how on earth do we do that if we can't get in those rooms that Harry was talking about and meet face to face and so on? And I'm going to hand back to Harry to explain how you can do all of this next week on Zoom.
Yeah, thanks, Joe. Yeah, and the reality is that you can do it. And in practice, mediation by remote platform, by Zoom, is strikingly similar actually to mediation done in person. It happens by video link. It happens most frequently by Zoom. That seems to be the preferred platform. It's the one that most people seem to use. It's certainly the one that I'm familiar with, and I have found it extraordinarily effective actually in delivering mediation. As I said, it's a really similar experience in many ways. So sort of thinking about the stages of a mediation, my pre-mediation preparation, which normally involves a bunch of phone calls and email exchanges with the clients, preparing themselves and myself for the mediation. Well, that's unchanged, no difference there. And then on the day of the mediation at the pre-arranged time, the parties click a link, as you have done today, to come to the mediation venue. I'm able to welcome them individually or in groups by party, and have a confidential conversation with them before I then invite them to enter a separate private room where they can catch up and discuss their strategy for the day. I can then invite everybody to join me in a larger virtual room where we can open the mediation formally. I can introduce matters. The parties, if they want to do so, can make some opening remarks, and a conversation of sorts can take place. The negotiation can commence in whatever way is appropriate. And I can then, after that, invite them to return to their private rooms, where they will probably spend most of the rest of the day discussing strategy with one another, or in meetings with me, who is shuttling between the various remote rooms, as I would normally do in a in-person mediation. And that's something that happens very efficiently and effectively. I can also set up separate private rooms where individual representatives of the parties might meet for the purposes of exploring particular issues. That might be lawyers, it might be experts on a particular matter, traffic engineers or acoustic engineers or whatever. And I can shuttle in and out of those rooms as well. And collectively, we can share screens. So we can look at documents together, we can annotate one another's documents, and we can work up an agreement at the end of the day. And so we can look at a whole bunch of different kinds of documents that might be useful in the context of a mediation, whether that's planning permissions or plans or photographs that might normally be relevant to an enforcement appeal, almost as easily as we can in real life. In that sense, Zoom provides a really effective alternative. There are some drawbacks. I think there's no denying that. The flow of conversation doesn't work in quite the same way. There's no real role for body language or sort of the non-verbal cues that can be really important in the context of difficult discussions. That just doesn't really work by Zoom. But my experience is that one gets used to that pretty quickly, and that we adapt. And you're probably already adapting, because I'm sure you've all used these remote video software platforms over the course of the last few months. Something that isn't possible in a remote mediation is the sort of thing that happens a bit in a in-person mediation, which is the kind of informal, casual exchanges between people that happen in corridors, outside the toilets, or over the coffee machine. But I always encourage my clients to set up a WhatsApp group between one another and to communicate with one another individually by WhatsApp, or even indeed by phone. And my experience is that provides a pretty good alternative, actually. There are inevitably technical difficulties. People's connections drop out. Someone presses the wrong button and manages to eject themselves from the mediation. But that's the sort of thing that can be quite easily dealt with. And let's be honest about it, those sort of logistical problems occur in the course of real life mediations in different but similar ways. If people are late because they're delayed in traffic or on the train, or they're not well, or there's a technical problem there. So no mediation is immune from that sort of issue. And then there are, of course, the inevitable interruptions from people like partners and kids and even pets. And some people might think those are disadvantages. I actually experience suggests that they can add a sort of note of lightheartedness to a mediation that I think can be really helpful. So I don't mind about that sort of thing when it happens. And there are clearly a bunch of advantages to doing mediation this way. I mean, the most obvious one is that we can carry on doing it in circumstances where much of the economy, and particularly the legal industry, has been forced to grind to a halt. That, I think, is something that's really important. Logistically, remote mediations seem to be easier to arrange than in-person mediations. That's probably partly because we're all working from home, and so our commitments are fewer and further between. But they're also cheaper. Nobody's spending lots of money on expensive but disgusting lunches, or expensive but airless conference rooms. There's no travel. Our carbon footprint is reduced, and these are all things in favour of mediating remotely. I think there's probably something a bit more important and less flippant, which is that mediating remotely, certainly the feedback that I've had from a number of clients suggests that mediating remotely is a less stressful, a more relaxing, a less tiring process in many respects than mediating in the conventional way, because there's no obligation to travel to an unfamiliar set of offices and sit in an unfamiliar room for the course of the day. One can do it in your own kitchen or your own sitting room, surrounded by the stuff that makes people feel comfortable. And personally, the opportunity to mediate only a few yards from my own larder, I find really useful, actually. So look, there are pros and cons. Overall, it's working. The feedback that we've had from our clients and my personal experience of it is all really, really positive, actually. So much so that I think, and I've heard this said by others, that mediation by remote video link may well continue to be a part of the dispute resolution culture even post-lockdown. And I think that says a lot about the capacity of mediation done in this way to deliver. So I think that's probably all I wanted to say about how it works remotely in principle. Joe, are you going to talk a bit about just a real life example at this stage?
Yeah, very swiftly before I want to get on to questions. There's a few coming in, and I know there's lots of more that we've got on our list. So I was just going to give a brief example of the kind of case that might well be ripe for mediation. I'm not saying it would be solved by this, but the kind of case I've got in mind, although there are obviously hundreds and hundreds of variations on this, is the sort of classic enforcement case of a slightly scruffy yard type site on the edge of a settlement, maybe where there's been, I don't know, a bit of horticulture in the past, some general storage, some of it open, some of it inside, maybe some low-level aggregates or waste storage. Some informal buildings have gone up, maybe they've been adapted with or without planning permission. Maybe there's a certificate on some of the land, but there's a bit of a dispute about how far that extends. And so your kind of classic mixed use site. In a case like that, mediation can offer a bunch of different things. It can offer, as I've said already, the opportunity for both sides to understand where the other side is coming from in a more informal way. It allows the local planning authority, insofar as it hasn't already, to get a sense of the facts. So to at least find out what the other side is saying has developed and when, and why and where. But perhaps more importantly, it also allows the landowner, recipient of the notice, to understand why what they've done is considered to be a breach of planning control, why it's unhelpful or unattractive or whatever, and where the local planning authority is coming from. So there's that kind of exchange of knowledge. As I've said already, often there's a solution on a site like that which takes into account a kind of holistic approach, and mediation can discuss that. It might be that the particular building that's being extended isn't appropriate for reasons to do with intrusiveness, but if it was somewhere else, it might benefit from PD, for example. The landowner hadn't thought about that, for example. And ultimately, even if it doesn't produce a resolution, a final resolution, what it can definitely do is narrow the issue. So it may well be, in a classic enforcement case, that you, by discussion and mediation, get rid of all the grounds B through to G, and all you're left with is really ground A, which is, please can I have planning permission for what I've done, and maybe if I move that building or remove that hard standing that I laid, could I have planning permission for this amount under ground E? So you under ground A, sorry. So it can, even if it doesn't succeed in providing a final resolution, we're going to talk about that in a minute, it can reduce the grounds that are at issue, reduce the issues, and as we know, if you get rid of ground D, quite often you can then think about whether an inquiry is necessary at all, and could it be dealt with by a hearing or even written reps if it was down to ground A. So there is real work to be done, even if you don't resolve the dispute completely. But that isn't to take away from the fact that I think lots of disputes will be resolved completely by mediation. So that's my sort of example, if you like. Shall we move on to the questions? Harry, if you unmute yourself too, then we can perhaps sort of take it in turns. I think you were going to answer Ben Temple's question. I hope Ben's still here, about whether a party can be forced to mediate and or be penalised in costs for refusing to mediate.
Yeah, thanks, Ben. That's a good question. The answer is that mediation is never compulsory, at least not outside the family law context. And I don't do any family work, but my understanding is that in some family law contexts, mediation is compulsory. I don't know to what extent that affects its success rate. Certainly, my view is that the voluntary nature of mediation is crucial to its effectiveness. But outside the family law context and in the civil litigation world, whilst not capable of being forced upon somebody, parties can be encouraged, in quotes, to mediate through the use of cost sanctions. And the courts are increasingly readily awarding costs against parties who refuse unreasonably to engage in mediation when offered. And that's very much a firmly established proposition of law today. As far as I know, there is no precedent for applying that in the context of planning law. But if one looks at the PPG on costs in the context of planning and enforcement appeals, then one sees that costs are awarded, as you will all be very well aware, for unreasonable behaviour. And whilst there's no specific reference to mediation within that paragraph, it seems to me that it would be within the spirit of the guidance to argue that a failure without good reason to engage in mediation, where it was said that that offered a realistic prospect of settlement, could amount to unreasonable behaviour. And I don't see any reason why an inspector or a Secretary of State or the Secretary of State shouldn't treat such an argument with real sympathy if it were made, particularly if presented with the very weighty body of cases that support that proposition in the context of the civil law system, or the civil litigation world, I should say. So no precedent, but I think it's coming. I think we're going to get to a point where inspectors are willing to consider applications on that basis. I hope that answers the question, Ben. I think Joe and I have answered a couple of the questions that have been typed today. Joe's answered one from Anthony Lenihan, and I've answered a question posed by Joe Hopkins. And I think Mark Tansley's asked a similar question to the one that Joe's asked, which I've answered. So I hope, Mark, that I've answered both of those questions in the answer to Joe's question. Other Joe, do you want to want to take? Were you going to answer a question from? Well, no, it was written down, wasn't it?
I can. Yeah, I was just going to say a bit more about that particular issue that we've answered in the text on the Q&A, which is, look, how do we enforce this agreement, and how does that fit in with planning? And Richard Clark has sort of answered it for us. I think he's right. One option, he says, I presume that a local planning authority can alter or vary the enforcement notice under 173A, so that the requirements then match with the negotiated solution. I think that's absolutely right. That's one of the options. Another option is that, well, frankly, one of the options is that the appeal is withdrawn. So the landowner understands that actually their grounds are a load of nonsense, but in the gentlest way climbs down the ladder that you've provided and withdraws their appeal. That doesn't need to be enforced because that's final. The other end of the scale, the local planning authority might agree to withdraw the enforcement notice subject to the right authority. There might be a situation where it's agreed that a new planning application might be put in. Obviously, you can't fetter the discretion of the council in terms of how to deal with that, but you could certainly come up with a mediation agreement which required a new application to be submitted following the terms of the mediated settlement, and then that could be dealt with. And if permission was not granted, then you might go on and litigate it, but if permission was granted, the mediation agreement would provide for that, bringing to an end the proceeding. So there's almost as many answers as there are issues here. Harry, I don't know if you want to say anything more, because I think it's quite an important point.
Yeah, I think that is an important point. It's complex, and I think this goes to one of the challenges of mediation in this world where authorities are treated and are subject to very different constraints and obligations to a typical commercial operator who's free to sort of act independent of any sort of statutory requirement or regime. And I think the only thing I'd add to what Joe has just said is that it isn't unusual for local authorities to commit in the context of mediation to making a recommendation to committee members where a decision needs to be ratified, making a recommendation of a certain type in a certain direction, and for that then to be put to members to ratify in the normal way. I mean, what an officer in the context of a situation where delegated powers don't exist can't do at a mediation is to bind the authority. But making a commitment, undertaking in the context of a mediation agreement to make a recommendation to members is a very common way of dealing with a situation like that, and no guarantees as to members' decisions can be offered, but my experience is that it's a brave committee that goes outside the terms of a recommendation insofar as that reflects what's been negotiated and agreed at a mediation.
Yeah, those are good questions, and thanks for submitting them. I'll just deal briefly with a question from Teresa Campion, who I feel like I've mentioned about 6 times already, but there was a sort of separate point in your question, Teresa, about stop notices, and will we see this lockdown and post-lockdown world resulting in more stop notices being served alongside enforcement notices? Well, we might, but I think both Harry and I don't think that would be a very sensible thing for a local authority to do based only on the COVID-19 lockdown problem. As you probably know, stop notices, in order to serve a stop notice along with an enforcement notice, you have to be satisfied as a local planning authority that it is expedient to require the activity. So stop notices only involve activity rather than particular buildings or whatever. Expedient to require that to stop before the enforcement notice period for compliance. Now, it doesn't seem to us that the lockdown or the COVID-19 slowdown has anything to say about whether it's expedient to stop the activity before the enforcement notice would require it to stop. So I think it would be a risky stop notice that said, well, we wouldn't normally serve this, but because we don't think we'll be able to have our appeal heard for 18 months, we're going to serve a stop notice too. I think that might end up in a JR. So maybe, but I think I don't think that's necessarily going to be the answer to any of this. Shall
I answer a question that Joe Hopkins has asked? And actually it's a question that Harriet Townsend, who I think Joe's a colleague of yours in Chambers. Hi, Joe, and hi, Harriet. About choosing a mediator. Harriet, Joe's asked, will or should the mediator have planning enforcement experience or knowledge of the planning system? And actually, Harriet has asked how one goes about choosing a mediator, and I'll deal with those two together if I may. There are increasing numbers of mediators available as the industry expands, as it has done over the course of the last few years. Mediators practice from both barristers' chambers and indeed solicitors' firms, and also from independent mediation panels and chambers like IPOS, which is my home. I think one of the ongoing, so mediators are easy to find if you know where to look, and I would advise going to the established and recognised places. Insofar as experience is concerned, and this reflects an ongoing debate within the mediation industry, actually, which is to what extent the mediator needs to have specialist experience of the subject matter of the debate, of the dispute. And my view, for what it's worth, is that it's really important that the mediator can, if you like, speak the language of the dispute, so that he or she understands the legal framework within which the dispute is taking place. Is able to build a relationship of confidence with the parties and their lawyers, and to understand the legal implications of that which is discussed in the context of the dispute and any terms of settlement that arise over the course of the day. And I think that's particularly important in the planning system, in mediations that take place in connection with planning disputes, because of the slightly more complex decision-making process that planning authorities have to go through, and because of the sort of wider public interest factor, that neither of which affect commercial organisations doing deals and making decisions without any cause for concern about the wider ramifications. And so I think the answer really is that some experience of the planning system is important when you're selecting a mediator for a planning dispute. Harriet also asks, actually, to what extent legal representation is important in a mediation. So whether parties should bring lawyers with them to the mediation, and there's no obligation to come with any representation to a mediation ever, actually. But my view is that some representation from the legal fraternity is almost always helpful for two reasons. Partly in an administrative way, because there's almost always quite a lot of work to do in terms of preparing for and managing the paperwork on the day. And partly because of the important advisory role that a lawyer can play in terms of acting as a sounding board in relation to proposed settlement terms, offering advice about strengths and weaknesses of different aspects of a party's case. And in terms of setting out the implications of any proposed agreements, and indeed including drafting the agreements itself. So I think legal representation is almost always helpful, so long as the lawyer understands that a mediation is a different world to litigation and their role needs to be adapted accordingly.
Should I jump in and deal with a couple of the ones that have come in live? We're sort of at the end of our 45 minutes, but if everyone else is happy for us to carry on, we'll just keep going until we've answered your questions. I think there's one from Natalie Robertson, which mirrors one that Richard Vivian, hello Richard, and hello Natalie, sent in advance, which is, what about mediation before formal action? Well, actually, that's a really good time to try mediation. Everything that I've said about narrowing issues and a collaborative approach and so on works just as much in a pre-formal action sphere as it does once things have kicked off on a formal footing. There's a long history of mediation narrowing disputes in other jurisdictions before you get to litigation and so on, so that when you do litigate, what you're litigating is the really intractable question. So you're only going to litigation, length, cost, heartache, and so on, when you really have to. And I think one of the things about planning and planning enforcement is that it doesn't always involve just one party and the council. There's often other parties too, and a pre-formal action mediation can often amount or get some buy-in from the community as to an agreed way forward. So I think that's a good question, or those are good questions, and I think that mediation definitely has a role. In a similar vein, a question from Talent Mazuku, hello, should the use of mediation be included in the enforcement plan or protocol? I think that's probably what you mean, or should it just be assumed to form part? Well, I think both Harry and I would say that we would like to see a world in which a local authority enforcement protocol said we will always consider referring an enforcement case to mediation once an appeal comes in, for example, or before taking action. Now, we're not there yet, but that would be one way of achieving some more public buy-in to mediation, being clear about what to expect and so on and so forth. So I think I would like to see it. Generally, if something is going to be done as a matter of course, then it's a good idea to put it in a policy. So I think the answer is that I would hope so. And then Harry, do you want to deal with Steve Jones and costs?
Yeah, sure. I will, Steve, that's a good question. I mean, like everything else in a mediation, costs are up for grabs. And so there's no, you're right to say that there are no winners or losers. And in the same way, there's no automatic rule insofar as the way that costs are dealt with. They simply fall to be negotiated in the mix along with everything else. And in civil litigation, and the closer one gets to trial, the more important, the more difficult actually the issue of costs is to resolve. And often one reaches a stage when the value of the cost claims on both sides begin to approach the value of the claim itself. And that's when a mediation becomes increasingly difficult to deal with. And it's one reason why I think it's important to, that's why a lot of mediators think it's important to mediate cases early before costs escalate too much. There's a question from Natalie Banks, which I think was submitted before the webinar, which I might deal with quickly, Joe. She asks about how one deals with the legality of documents. I think the answer in simple terms is this: that simple agreements can be dealt with on the day, thrashed out by lawyers over computer screens and exchanged remotely at the end of the session, signed electronically is the way in which it works in the current lockdown context. Where there are more complex and subtle arrangements to be provided in an agreement, such as, for example, the schedule of works or legal formalities insofar as land is concerned, then they can be dealt with and are often dealt with by signing up to heads of terms and then being settled by lawyers in the immediate aftermath of the mediation, and both are common.
Shall I deal with, I think, the last of the live ones? Philip Stanley, it's a two-part question, but actually I think it's just one question with a stray press of the return key in between. Is the PINS case management meeting, so these new case management hearings on the telephone, a type of mediation? It's a good question. It depends on the inspector. I think some of them probably are. Yeah, I mean, certainly I've been to some where the inspector in those case management hearings will push quite hard on particular points. Is that really an issue? How does this fit with this? Other inspectors are totally passive in those meetings, certainly in terms of the substantive issues, and just want to get a list of what the issues are and how long each is going to take. So yes, it's a type of mediation, but I don't think planning inspectors are trained in the skills of a mediator, so it doesn't always work. And secondly, it depends very much on which inspector you get. So that made me smile, that question. I don't know if it was meant to, but it did. And then Nicola Swan, who I see from the list is still here, or was a couple of minutes ago, waiting patiently to talk about drones. Only tangentially related to mediation. You can't do a mediation by drone yet, I don't think, but it must be coming. But the question is, are drones going to be used more in planning enforcement? I think the answer is my understanding is they're already being used. I know of at least 2 authorities who have considered using drones to do site visits, nothing to do with COVID, this is pre-COVID, where the site owner is secretive or obstructive in terms of getting onto the land, and they've had to go and get a warrant and take the police along. These were enforcement cases that had gone quite a long way down the line. So we were in the High Court on injunction proceedings, and it was a question of whether it was worth going to get another warrant to get onto the land to see if they'd done any more towards complying, which is a big rigmarole, or could we just send a drone up and have a look to see if the building or whatever had been removed? So they are being used. They may well be used more in the post-COVID social distancing world, but they come with their own sort of subspecies of problems. There's a RIPA issue, there's a data protection issue, probably a seminar in itself. I think my colleagues Tom Cosgrove and Ed Grant both have done an article on drones in planning, so it might be worth Googling those. Before we finish, Harry, I think that's all the questions. I was just going to say, you will have all, I hope, seen the little leaflet that Harry and I have produced, which provides a bit more detail about mediation and planning enforcement. But we'd also like to extend an open invitation to all and any of you to get in contact with us. I'll put the slide up in a moment. If you want to talk about this further, we can do it by Zoom. It's relatively easy to arrange. My wife is due to give birth on Thursday, so if you want to do it on Thursday, I probably am not going to be available, but in a slightly longer term view.
Maybe even Friday, Joe, as well.
Friday, exactly. But we would be very keen to talk about it more. Obviously, you're all going to have your own questions. We haven't been able to cover everything exhaustively today, but we'd be more than happy to come and meet you virtually by Zoom if you wanted to have a more in-depth or in-detail chat about it. I'll just put I'll try and put the slide up now. Hold on a sec. And you'll have our email addresses and those of our clerks. That probably doesn't show you what I want it to show you, but it will if I do that, I think. So
yeah, thanks, Joe. Well done. I was just going to add to that I think that when it's a source of some frustration on my part, actually, that mediation isn't more widely used in the local government world and the public sector more generally. I mean, my view is that it has the capacity to save huge numbers of I was going to say huge numbers of public pounds, huge amounts of public resource, and to do that thing that Joe was talking about earlier, which is to help to preserve relationships from which stakeholders can't escape into the longer term in a really valuable way. And Joe and I think we both encourage you to explore it as a solution to some of your disputes. Other than that, many thanks for your time. Thanks for listening. I hope it's been helpful. And like Joe, I'd be delighted to talk to anybody who's keen to explore this further over the course of the coming days and weeks.
Thanks very much, everybody.